You've got a homeowner, you've got a powerful association, and a fight that goes all the way to court. It sounds like a classic neighborhood drama, right? But what actually happens when the lawyers get involved? Well, we're about to pull back the curtain and find out. That is the big question, and we're going to answer it by diving deep into a real-life case, a formal petition a homeowner filed against his HOA. We're going to follow the evidence, listen to the arguments, and break down the final decision to see how these conflicts really get solved, and more importantly, what it means for you if you live in one of these communities. So here's our game plan. We'll start at the very beginning, with the spark that lit the fuse. Then we'll look at the two big issues at the heart of this lawsuit. After that, we'll see how it all played out in court. And finally, we'll get to the judge's decision and figure out what we can all learn from this. All right, so our story begins with a homeowner, George Holub, and the Three Canyons Ranch Homeowners Association out in Arizona. And like a lot of these disputes, this one didn't just explode out of nowhere. It was more like a slow burn, a couple of different issues that finally pushed Mr. Holub to take formal legal action. When you strip it all away, this whole thing really came down to two things. First, a bill for a fee that seemed way, way too high. And second, a $500 fine for a wall that the HOA said was never approved. Each of these tells its own little story about rules, communication, and who's responsible for what. So let's tackle the money problem first. So the thing that really set this whole conflict on fire was the annual assessment. The homeowner, Mr. Holub, he was expecting a bill for something like $500. But what he got in the mail was a statement for almost 3 times that. As you can imagine, that set off some serious alarm bells and a whole lot of suspicion. Look at that number, $1,495. The normal annual fee was supposed to be just $525. So when this bill landed, Mr. Holub didn't just think it was a mistake. He thought something really shady was going on, maybe even on purpose. And this quote right here, from his actual testimony, shows you just how high the stakes felt to him. He didn't see this as some simple accounting error. No, he truly believed that HOA was making a move, trying to foreclose and take his home. So this slide really lays it all out. On one side, you have the homeowner who's saying, hey, you illegally doubled my fee. That's against state law. But on the other side, the HOA is saying, whoa, hold on. It was just a simple clerical mistake. We accidentally bundled the fine and a past due amount. We fixed it as soon as you told us. 2 totally different versions of reality. Okay, now for the second big piece of the puzzle, the wall. This part of the fight started when the homeowner began building a new courtyard and wall without getting approval from the HOA's design review committee first. And well, that's a pretty clear violation of the community rules. Let's just walk through the timeline here. Mr. Holub buys the place in May. By August, he's already started construction. A month later, in mid-September, the HOA sends out a formal violation notice. But this is where things get really interesting, because how they sent it and whether he actually got it became a huge deal in court. So the HOA, trying to do things by the book, sent the first notice using certified mail. This is totally standard procedure. It's how you create an official paper trail so you can prove you sent something. But here's the snag. The letter came right back, stamped undeliverable by the post office. Now, from the homeowner's point of view, that seems like a pretty solid defense, right? I mean, how can you fine me for something you never officially told me about? So you think that's game over for the HOA. If the certified mail didn't get there, their case for the fine kind of falls apart, right? Well, not so fast. The paper trail didn't end there. And there it is, the smoking gun. After the certified letter bounced, the HOA tried again, but this time, they just sent the notice by email. And Mr. Holub himself replied with 2 little words, just got it. That 2-word email became the undeniable proof that yes, he had absolutely received the notice. With neither side willing to back down, the whole dispute headed to an administrative hearing. This is basically where both sides get to tell their story to a judge who looks at all the evidence and makes a final legal ruling based on the facts and the law. So in court, it was all laid out nice and neat. For the assessment fee, you had the homeowner's claim of an illegal increase versus the HOA's evidence of a corrected ledger. And for that $500 fine, it was his word that he never got the notice against his own email saying he did. And now we get to the moment of truth. After hearing all the arguments and looking at all the documents, the judge had to make a call. But before we get to the final ruling, we gotta quickly understand the legal measuring stick the judge was using.
You know how in crime shows it's always beyond a reasonable doubt? Well, in a civil case like this, it's different. The standard is called preponderance of the evidence. All that means is the judge just has to be convinced that one side's story is more likely, even just 51% more likely, to be true than the others. It's a much lower bar. So, on the first issue, that big, scary assessment fee, how did the judge rule? No violation. The judge sided with the HOA. The evidence, especially that corrected ledger, convinced him that it really was just a simple clerical error, not some illegal scheme to overcharge the homeowner. And what about that $500 fine for the wall? Again, the judge ruled for the HOA. Even though the fancy certified mail failed, the judge decided that the "just got it" email was proof enough. Mr. Holub was properly notified, and he had plenty of time to fix the problem before the fine was actually put in place. And get this, the judge didn't just rule against the homeowner, he used some pretty strong language in his final decision. He called Mr. Holub's claim disingenuous. Why? Because it turned out that Mr. Holub had put the property in the name of his LLC, but he'd never actually given the HOA the correct mailing address for that LLC, and that was his responsibility. So, at the end of the day, the HOA won this legal battle because they had their paperwork in order. They had the receipts, literally. But this whole thing makes you wonder, doesn't it? In these community disputes, what's actually more important? Following the letter of the law to win a fight? Or having the kind of clear, open communication that stops these fights from ever happening in the first place? Something to think about.